Let's see. Mr. Goggins. Good morning, Counsel. I understand that you will have 7 minutes. Ms. Sullivan will have 5 minutes. She will then have another 5 minutes, and Mr. Gallant will have 3 minutes. Do I have this more or less correct?
Yes.
With no interruptions, Ms. Sullivan, you can talk flat out for 10 minutes. Okay. Have we called both cases, Ms. Mallon? Thanks. Mr. Goggins.
May it please the Court, John Goggins for Attorney John Doe in this matter. This is a matter where a client left several voicemails on an attorney's voicemail machine, or several messages in the wee hours of November 8th, 2007, basically expressing dissatisfaction and concern about the judicial system and judges in general. The lawyer at some point felt some concern, and some 13 days later made a rule of professional conduct 1.6 disclosure to the justice that he thought may have been mentioned in these messages, and then informed the state police. Subsequent to that, the Commonwealth took out a complaint in the district court against the client, this would be Mr. Gallant, and started proceedings against Mr. Gallant and holding him. At some point, the matter was presented to the grand jury. The district attorney's office brought in a motion to summons in the lawyer to testify before the grand jury. The lawyer, through other counsel, sought to have that motion quashed. That was denied. I entered my appearance, and then I brought a motion to reconsider, as well as asking for an evidentiary hearing, which was denied as well. And there was a joint request to bring it up before the appeals court on a reported question, and this court took it sua sponte. The basic position is that any of the statements that the client made to the attorney on his voicemail are privileged, and that anything that he said in those voicemails are privileged under the attorney-client privilege.
But what is there from the evidence, I'm just wondering, that indicates that he was seeking legal advice other than just spouting off?
You know, some people are intelligent, they're educated, they're well-versed, they're articulate, and they call up and say, I'm seeking legal advice.
No, I understand. So, okay.
What we're dealing here is probably at 1 o'clock in the morning. We're not dealing with probably the most intelligent people. And people calling out and expressing opinions
Go ahead.
in matters that relate to the case, I would suggest, is in the context of seeking legal advice.
Well, surely the issue is whether the relationship, I mean, the attorney-client privilege is, do you go to that person to seek legal advice? There are then many conversations that have to do with, you know, all kinds of things in the context of that, correct? I don't think you have to show that every communication is you're seeking legal advice in that communication. At least I don't know of any case that holds that.
No,
So you're saying that he was venting with his lawyer?
that he was irritated with his lawyer?
No, he said venting. Venting.
He was just frustrated and communicating that frustration to his lawyer.
Absolutely. I've been doing this as a prosecution and as a defense attorney for approximately 13 years. I don't think there's a lawyer in this room that hasn't got a call from a client expressing outrage, frustration, and saying things in the heat of the moment that are very upsetting and possibly very frightful at the same time, concerning what a judge did with a case, whether a decision was rendered properly, what a jury may have done, what was the progress of the case, and things of that nature. You have a lawyer who's been representing this person since March 6th of 2007. The client calls, leaves a message pertaining to his case, discussing the particular judge in the case and other matters, including a social worker in his case, and expressing, certainly at the very least, his opinion and his frustration. I would suggest respectfully to what was reported to the Superior Court judge that there was no evidence of a threat. There was, you know, certainly...
Is this, if I could just interrupt you, in Purcell,
Yes.
I just don't remember this. Was there a discussion about when the person, the client said, you know, I'm going to burn down the building or whatever, was there any discussion about whether that was seeking legal advice, or was that just assumed because he was representing this that it was part of the attorney-client relationship?
Well, in Purcell, Mr. Tyree was the client.
Tyree, thank you.
And Tyree went to a legal services clinic to get some advice on an eviction proceeding. And then during that particular consultation with the lawyer, he specifically made a threat to burn down the building. He made a specific threat about a specific object and did that.
Oh, so it was part of a larger conversation.
Yes. Well, the facts are very brief in the Purcell case. You don't know whether the representation continued or stopped, but it certainly seems that in the initial consultation, the client made a specific threat to burn down a specific building. Here, we don't have that. We don't have any specific threats. You have a guy that's calling up, I know where the judge lives. Some people need to be exterminated with prejudice, and a bunch of other things. And most importantly, says, I know I'm not committing a crime because I'm not mentioning anybody specific.
Well, is your main argument that there were no threats?
My main argument is that whatever was said in this context falls squarely within the scope of the attorney-client privilege, period.
Here's the problem. We have permitted attorneys in certain circumstances to disclose certain communications. The fact that we permit them, that we expressly permit them to disclose certain communications, of which a particular threat to injure somebody or to burn down a building would surely qualify to engage in a crime, assumes that the communications are privileged.
Yes, I agree.
And assumes that the privilege can be breached.
Under circumstances such as, and the only circumstance that I'm aware of is the crime fraud exception. If you look at the Maryland case...
So we've permitted that,
Yes.
correct? Once a breach, generally speaking.
I disagree with that.
Well, maybe, okay, you'll disagree with that, but let's assume you may think that the attorney should not have disclosed, correct?
Not necessarily.
Okay. And I take it that you would then say the privilege belongs to the client and the attorney can't be required to testify about it again.
Yes. And here's why, if I may. 1.6 is a limited disclosure. Specifically, this court said in the last paragraph of Purcell that that's a limited disclosure. The Newman case that I cited out of Maryland embraces the Purcell decision and this court's decision of it, and specifically addresses and tangentially refers to this court's decision in Purcell about the balance that needs to be walked between a 1.6 disclosure and a disclosure for all purposes. It's one thing to walk up to the judge and say, hey, look, I think someone may hurt you. It's another thing then to take that privileged statement and then use it as the only evidence against the client and enforce or compel testimony against the client based on what the client talked to the lawyer. And specifically, this court in Purcell said this type of factual scenario is why we strictly construe the attorney-client privilege. And this is a strictly construed privilege in this particular matter, notwithstanding that it's a testimonial privilege. Purcell says that. And that the fact that a client may say something about a crime, that's protected. And we suggest to you that, very briefly, that the protection and the 1.6 disclosure is something distinct from a full-blown prosecution and having everybody come in. And incidentally, in the Purcell matter, there was other evidence that came in as well. They executed a search warrant, and they found incendiary devices and gasoline and things of that nature.
Thank you, Mr. Goggins. Ms. Sullivan?
Good morning. May it please the Court. Jane Sullivan for the Commonwealth. The Commonwealth would ask this Court to respond no to the reported question, that the messages at issue were not protected by the attorney-client privilege, and I'd ask the Court to affirm the order compelling the attorney to testify before the grand jury and to remand this case to the Superior Court for further grand jury proceedings. This is not a Purcell case. In Purcell, the parties or the Court assumed that the statements, the comments at issue were protected by the attorney-client privilege and went straight, as the motion judge below had, went straight to the issue of whether or not the crime fraud exception to the attorney-client privilege applied. And that the record, the evidence before the motion judge, there hadn't been an in-camera hearing or anything, was insufficient to warrant a conclusion, a proof beyond a by a preponderance of the evidence that the crime fraud exception applied. But the case.
And you agree it doesn't apply here either?
No, no. We're starting where Purcell perhaps should have started. We're saying that the attorney-client privilege does not apply to these. They were 6 messages left on an answering machine in the middle of the night within 16 minutes in rapid succession.
Are you saying that there has to be conversation between the attorney and the client?
No, I'm sure there can be a letter.
A client can leave, then it's okay for a client to leave messages.
Perhaps. I mean, I think that it depends on the context in which they are read. All we have here.
Why can't a client vent with their lawyer about a case?
A client perhaps can vent, but that doesn't necessarily mean that it's protected by the attorney-client privilege. The only communications that are protected by an attorney-client privilege are those that are made in the course of seeking legal advice or assistance.
Comb through every conversation that occurs in a long an attorney-client relationship that goes over a long period of time and decide which ones are covered by the privilege and which ones aren't? Is that what you're suggesting? That we
No, suggesting as a practical matter in every case, that's just impossible. Certainly the
Well, Ms.
Commonwealth
Sullivan,
cannot.
the converse is even more troubling, which is that a client enters into a client goes to attorney to get attorney's advice. Absolutely. No question.
There's a case.
In the course of that, has various discussions with the client. I think all of us know that these communications include all kinds of things, discussions about the weather, discussions about the family, discussions about how irritated you are with the judge's ruling, I can't believe, and so on and so forth. And let's just assume that in the course of that, they're talking about, it may be, the hearing has been scheduled for the day after Thanksgiving. That's the communication that the attorney wants to give. And in the course of that, there's a long discourse about, can't believe the judge is doing this, we've got family responsibilities, and oh, by the way, my ex-spouse is doing da-da-da-da-da-da. This is a case where the domestic issue is not the legal issue. You think that attorney is free to say, well, that wasn't an attorney-client privilege, and so I can't go and disclose that?
I think perhaps the attorney possibly could be free to be able to disclose that, but under the ethical rules, the attorney is free.
I think that would be a most surprising conclusion that any attorney would draw. That because somebody conveys something, when you're in an attorney-client relationship, the fact that you convey information that is not directly on point for that you can then go and disclose that. Do you know of any case that has held that?
Well, no, the cases that I am relying on.
No, I'm just asking you. Do you know of any?
No, I
Okay.
don't in that broad. But we're not there in this case. What we have is that the defendant's or the client's messages were threatening. He mentions that some people need to be exterminated with prejudice, mentions the particular judge by name, knows where the judge lives, and knows that the judge has children. The attorney himself recognized that there were some parts of the conversations or the messages that may have been privileged, some parts not, only disclosed to the trooper and to the judge those that the attorney thought he was allowed to disclose under the ethical rules, those that threatened serious harm and threatened an intent to kill a particular judge.
Potentially did. Potentially. I mean, the lawyer didn't get on the phone and call the police right away. It was days later when the lawyer, based on further observations of how agitated his client had become, decided that this was something under the rule.
This was possibly a real possibility, and yes, and that's where he was compelled.
Aren't we better off approaching this by saying, was this a valid disclosure under 1.6? And if it was, what are the implications of that? Because we have, in essence, said we have presumed that it's privileged, which is not a bad starting place, but to say in certain circumstances you can disclose, right?
Right, but the burden is on the party asserting the privilege to prove that it's privileged, and it's a matter of it's a factual determination to be made by the.
Well, then you're not relying on 1.6.
Excuse me?
Then there's no reliance on 1.6. In other words, 1.6 almost by definition says that the particular information is not privileged. It's taking place within a privileged context, and I think that by looking at it to say this particular statement is privileged is not the correct way to look at it. It's saying I'm in a privileged relationship where, for all intents and purposes, everything that gets said is privileged, because the relationship is a privileged relationship, everything. But we have said, the court has said, you can disclose certain things, provided that it is consistent with that rule. Then the question becomes, I think, what can the person to whom there has been an appropriate disclosure do with that information? And it seems to me that what you are then out of, at least there's an argument, is that those communications, provided they fit within 1.6, if they ever were privileged, are no longer privileged. Now, obviously, the defendants would take issue with that. And they would say, no, I've made the disclosure, but the statements are still privileged. And, but it seems that, to me, at least to me, at this point, that that's a better way to look at it.
Well, perhaps it is. Perhaps that would be, Your Honor. I mean, but our position was simply that those statements, whether you look at them through 1.6 or whatever, are not protected by the attorney-client privilege because...
I have a further question, though. If we look at it and say, I know that a Superior Court judge didn't rule on those grounds, but if we say it is covered by the attorney-client privilege, just assume that we say that. Mm-hmm. But we say that it comes within the exception of the crime fraud exception of 1.6. But then I have this question. The exception permits the attorney to disclose the information in order to prevent the commission of a criminal or fraudulent act. But does the exception go so far as to permit the attorney to disclose the information for purposes of prosecuting the defendant? That's the next step. Assume that we agree with you, at least to the point that this is disclosable because of the crime fraud exception. So you win at least part of the app. You don't get it all, but you get half of it. So then, because 1.6 permits the disclosure to prevent the commission of a crime, does it also permit disclosure for purposes of prosecuting the defendant?
Well, the crime fraud exception is an exception to the attorney-client privilege, so I would assume that if the attorney-client, if there's an exception to the privilege, then it comes in. But the Commonwealth's position has been from the beginning that this isn't a crime fraud. We're not saying that the defendant left these messages in order to seek legal advice on how to kill the judge. That's not what we're saying. And I think that's what the crime fraud, I think under Purcell, that's what the crime fraud exception requires proof of. I think
no, but Purcell speaks at least fairly directly to this point. I mean, a disclosure under 1.6 is permitted, but it doesn't vitiate the attorney-client privilege. So 1.6 is pretty much a separate issue here. You're saying the nature of the statements made here are simply not covered from the get-go by the attorney-client privilege.
It's just these particular statements. And
even if they were, you would say, because since we don't know the entire extent of the messages here, the message could be, what are we going to do about this? We just lost the case today. I am beside myself, and then goes on to make these statements. That certainly would be a phone call seeking legal advice. What are we going to do about this? I've lost the case. And then a rant about how angry he is in precisely the words that are here. Wouldn't that be covered by the attorney-client privilege?
Possibly. It possibly could be covered by the attorney-client privilege. But if it discloses a crime, like a threatened commission, and I would just direct the court.
1.6, he can do a 1.6. That's fine. I'm assuming he can do a 1.6.
Okay. No, but I think and above and beyond that, where it discloses his intention to commit a crime.
But that's what one point, I mean, when you said, I don't know about, when you use crime fraud, there may be other conditions, but at one point, it seemed to me, as I read this, that 1.6b1, which says may or must, and we don't have to decide that here, reveal information to prevent the commission of a criminal act. It seemed to me that that's what this lawyer at least implicitly was doing.
Yes, and I've argued...
This lawyer was implicitly assuming that a criminal act was could occur.
Yes, Your Honor.
correct?
Yes, I believe so.
And that, by the way, was based not just on the telephone conversations, but on, as I understand it, at least in this case, on observations of the client, which nobody disputes were observed in the course of an attorney-client relationship. Right?
Excuse me, what was the last part?
That the observations, increasing agitation, were observed in the course of an attorney-client relationship. In other words, he wasn't just sitting down at a cafe somewhere.
Well, we don't, I don't know. I don't
I
believe
don't know,
that
but
that's
I
brought
can-
out on the record at all. There was
I would just
Yeah.
presume that.
Okay.
That these are not friends. This is an attorney-client relationship. Right? They're not at a Christmas party together. They are having some interactions that are, at least I can infer that, reasonably infer that. And then you're under 1.6, which says that a lawyer may or must, in certain sanctions, reveal this. This lawyer thought about it very carefully, no doubt consulted counsel, might have consulted counsel, and proceeds under Rule 1.6. So we don't even have to decide. All we have to decide with the concerns expressed by Justice Cowan is what use can be made of that information once it is disclosed.
Then once it is disclosed, and I would suggest that whatever use can be made of that information should be made of that information. It was disclosed to police officers, to the state troopers. It was disclosed to the judge, and so that perhaps there is a waiver of the attorney-client privilege.
Wouldn't the policy implication of that be that the attorney would never disclose because of the fear that the
That you are-
privilege was being waived?
Perhaps our argument was from the get that these particular messages just simply were
I
not.
know. You
Okay.
keep saying that, and I keep trying to provide you with alternative ways to get to a resolution.
Okay, yes, Your Honor.
Okay, because at least from my point of view, at the moment, that argument is not going to prevail. I don't care about what the time of day and night is because I'm prepared to state that when I leave late at night and when I come in the morning, if I'm a lawyer, there are messages on my voicemail. The fact that it's agitated isn't going to do it. The fact that it isn't preceded by, I'm calling you to express outrage rather than what am I going to do about the case. The conundrum here is a lawyer has proceeded to disclose.
Yes, Your Honor.
Can that be used only to prevent the crime from being committed? In other words, to provide protection or to make sure, in other words, in whatever the form of protection is, or can it be used to prosecute?
And I would argue that it should be able to be used to prosecute, and particularly in these particular circumstances.
And are there what are the cases that on which you rely where there's been a disclosure, an authorized disclosure of an attorney-client privilege communication? I know you say it's not. I'm saying, are there any cases where there's been an authorized disclosure of an attorney-client privilege communication which has formed the basis of a prosecution because of the content of those disclosures?
I believe there are at least two cited in my brief. One is the United States versus Alexander case.
Right?
Yes, and that was an attorney who was called to testify before the grand jury, and during the course of a representation, the defendant had made threats to kill, I believe, the prosecutor, the public defender, maybe even the judge. And the Hansen case.
And in that case, because I just don't recall, had the attorney disclosed that?
I believe, yes. I believe that the attorney had disclosed that,
Okay.
but then by the time of the grand jury, similar to here, by the time of the grand jury proceedings, had moved to quash or whatever, to oppose testifying before the grand jury. And that court gets into the discussion that, no, that particular conversation, the threat to kill a judge, a prosecutor, a defender, is not protected by the attorney-client privilege so the attorney could testify. And there was a similar case cited to Commonwealth versus Hansen, and that's also cited in my case, and that's a Washington case. A similar thing.
But that case
there
really...
was a question of whether or not there was even an attorney-client
Right.
privilege. But the
He had not engaged the attorney. Was it
Right, he had not
preliminary?
engaged the attorney, but the court went on to say that even if he had, and there had been an attorney-client privilege, this is the sort of thing that is not protected by an attorney-client privilege, these types of statements. And that was basically our argument to the judge below, and that is why, and the judge found that, no, they were not protected by the attorney-client privilege.
What was the year of those cases, Alexander and Hansen?
2002, is that?
2002, I believe, was Hansen,
No, Alexander's 2002 as well.
Excuse me, yeah, Alexander was 2002.
And Hanson is 1993.
Thank you, Your Honor.
Thank you.
And
You've
if
had...
I may, just quickly, the Commonwealth...
Are we into her 25 minutes?
I know, I apologize.
That's perfectly okay. Go ahead.
apologize,
I'll give opposing counsel time as well.
The companion case is essentially on reservation report from the single justice on the Commonwealth's petition concerning the pretrial detention order. The defendant in this case was arraigned in November.
I have a factual question, if I could, or one or two. First of all, what is the defendant's status now? Is he at Bridgewater or in a jail?
He is still under the Department of Mental Health, but he has been moved from Bridgewater, I believe, to the Worcester State Hospital. So he is not in jail. And at the time, these cases were on sort of a dual track. They started in the district court, and while they were pending in the district court, we moved.
I think we're familiar with the facts,
Okay.
but does the defendant have any standing to contest the question of the grand jury subpoena to Attorney Doe? What is the defendant's? It's his privilege, so he can.
It's his privilege, and I believe it was always represented below either, I'm not,
Right,
the
and what
defendant had not waived any privilege that
And
he
what
had.
form did his objection to the attorney testifying take? I didn't get that from reading the briefs. What, did someone come in representing him at the court and object? I mean, I don't understand.
Yes, I believe that the attorney for the attorney as well as the attorney for the client, Gallant, were present during the Superior Court, the grand jury proceedings.
And
there were papers
for
filed.
the defendant actually objected in the district court proceedings?
Yeah, the defendant, well, he filed a motion to dismiss the complaints, and he also, and as part of that motion to dismiss on December 20th, he filed an affidavit saying that he did not waive the attorney-client privilege. And I believe that was what it was, and it may have been that the attorney was bringing up the privilege on behalf of the client. But I know that the defendant and his attorney were present in both the district court proceedings and the Superior Court proceedings, and there were pleadings filed.
Did you appealed from the dismissal of the complaints,
We
correct?
appealed from the dismissal of the
And that's in the
complaints.
appeals court?
And that is pending now in the appeals court, and, right, and and we also appealed the district court judge when we thought the case was going forward in the district court, and in order to comply with the 90-day detention term, the prosecutor asked for a date of February 19th within the 90 days.
And is the defendant then, was the defendant released from Bridgewater after his January 18th 08 commitment there, or?
No, he's been in Bridgewater. He was in Bridgewater.
He's been under DMH custody since January.
January 18th, when he was transferred from the jail to Bridgewater.
Okay.
He's done 6 months, and now I believe under 123(7) and 8, he's in for a year. But he's
All right.
at Worcester State
And then
Hospital.
moving to the substance here, does the interlocutory appeal referenced in Rule 36B2, does that include a report by a judge? You just assume that this is an interlocutory appeal.
Well, it's not necessarily this one, because the report is out of the Superior Court. But there was also a decision made by the district court judge. At the
Right.
time we moved for trial, and in order to go to trial, we had to have the attorney's testimony. We made a similar motion to compel the attorney's testimony. The district court judge, in a written motion in February 13th or so, denied it. We appealed that.
Is that here, or is that in the appeals court?
That was on a Rule 15 petition, and that's in the single justice session of this court. It's
So that hasn't been reported up here?
084.
It's just pending?
Yes.
So
that's
what's
just
here?
pending.
How did you get here?
What this is we also, at the time the judge dismissed the case and said that the attorney could not testify, he said, I'm also going to release him from the detention order. And that was in the middle of February. We asked him to stay the detention order because we're appealing his dismissal. We're trying to appeal his ruling on the attorney-client privilege, and also the defendant is in under the direction and control of the Department of Mental Health. The judge refused to do that, and he said he's going to be released unless you take an appeal. So we applied to the single justice, and the single justice issued a stay of the detention order pending further order of this court.
There's no report of the
There's been no report of
the matter of
the attorney-client privilege. It's essentially, there's been no report
So
of
this
that.
is an interlocutory appeal.
So This is a report on a 211.3 from our challenge to the judge's ruling on the detention order.
Well, because I'm trying to see if this fits under interlocutory appeal. So you came up to the single justice
Yes,
in an
we came.
interlocutory appeal, and
Yes,
then
we
he
did.
reported it here.
Yes, Your Honor.
Okay.
On the detention issue and on the dismissal, or excuse me, not on the
Sullivan,
the dismissals in the appeals court, and yes. And so
Okay.
we were just asked as set forth, excuse me.
I was going to say, I know the procedural questions are complicated. We will sort those out, but I think we really have to move on, and we have your briefs,
Thank you,
but
Your
thank
Honor.
you very
Thank you.
much. Okay.
Good morning, Your Honors.
Mr. Vukomirowicz.
Tom Vukomirowicz for Scott Gallant. Thank you. I wanted to devote the chunk of my argument time, the bulk of my argument time, to Attorney Goggins, who is here addressing the issues that seem to have the most concern. I'm just quite simply, Your Honor, the trial court did not abuse its discretion on its ruling concerning the excluded time period under 276-58A. The Commonwealth would have you look at Rule 36, which is expressly referenced by 276-58A, as to all the excluded time periods that would fall within the detention statute. But the Commonwealth would at the same time ignore Rule 15E, which is just the normal appellate process. And there's
Okay,
nothing.
but Rule 15B, correct me if I'm
15E,
wrong.
I'm sorry.
15E says the defendant may be released on personal pending appeal.
Right.
But isn't that assuming that nothing else is holding him?
Yes,
He can be released on personal pending appeal, assuming there's nothing else holding him. And here the Commonwealth says there is something else holding him, the dangerousness statute. And
Well,
the time hasn't run.
I think all I was trying to advocate on behalf of my client was just to obtain a hearing under Rule 15E, and I'm not here before this court or before the lower court to presume that the judge would have changed the order or released him on some sort of bail. But in the record appendix that I cited, that I included in my brief on page R20 and 21, the judge indicated that he was scheduling a hearing next week to allow the Commonwealth time to figure out what it's going to do. And also, at that point, that was just after the House of Correction had initiated its civil commitment.
So you're saying all you want is a hearing before the judge on whether the defendant should be released on bail?
On bail or personal recognizance, while the Commonwealth takes its appeal of the allowance of the motions to dismiss. The judge, in my opinion, saw this case for what it is and dismissed the case. I'm not here to say that to take threats against judges or anybody else lightly, but the facts of this case, Your Honor, was read by the trial court, and after.
How long has he been denied his liberty here?
Well, he was committed from January into September or October. He's been transferred to Worcester State Hospital early October. That was a 6-month commitment in Bridgewater. From what I am told or somewhat know, I believe that if he's released from Worcester State Hospital, then he would have to go back to the House of Correction under this detention order. He doesn't have to stay at the hospital for any length period of time. It's not like the commitment in Bridgewater, which had a 6-month expiration. He could be released at any time when they deem him.
What is he being held on now? For what?
He still
On
was.
his 6-month commitment? Or
He was
is that
still was committed under an order indicating that he had some mental health issues. However, his confinement was not deemed necessary to be in such a restrictive environment as Bridgewater. He was transferred to a less restrictive.
So there's some form of civil commitment there, which is holding him. And if
Yes.
he gets released from that, there's 58A, dangerousness conclusion. 90 days is long since passed. The only reason he'd be held under 58A is the Commonwealth has taken an appeal from the dismissal. And the question is whether or not that time is excluded.
Well, the Commonwealth has, in addition to taking an appeal from the dismissal, has moved to stay any further action. Has prevented my client from having a hearing as to whether or not he could or should be released on personal recognizance while the Commonwealth pursues all its appellate rights.
So if we rule for you and remand it for a hearing on whether he should be released, which would, I suppose, involve the interplay between Rule 36 and this other Rule 15E, then if there's a decision in your favor, then the Commonwealth could appeal from that and get to the merits, is that?
The Commonwealth has appealed on the merits, and that's been, that
But
was...
what I'm confused about is, do we get to the merits here if you just want a hearing? You say all you want is a hearing, you don't want a resolution on the merits, or did I misunderstand?
Well, I want a resolution on the merits eventually.
You do
but
or
the-
you don't, now?
Well, we have a resolution on the merits. It was, well, the case was dismissed.
You've got two merits. One is under 123(7) and 8, right? That's one merits, and the other is whether the case should have been dismissed. But you're concerned about the 123(7) and 8 at the moment.
I'm just concerned more on the
50.
the status of the criminal case. I just want him to be able to, if he's deemed to be suitable to be released from
You want a 58A hearing.
Yeah, well, I just want a hearing on the 15E to determine whether or not he should be held without bail or should be released,
Pending appeal,
pending all of the Commonwealth's appeals.
Right.
And
pending the dismissal appeal.
So is your argument essentially that the Commonwealth was premature in coming here?
No,
You should have had your hearing, and then,
my argument is that the Commonwealth is exercising its right under 211.3, which my argument is that this is really not a 211.3 situation. The Commonwealth has its ordinary appellate process by which it could pursue any adverse ruling it received in the district court. And this isn't a 211.3 case. This isn't a situation where they have no alternative remedies.
well, the complaint's been dismissed. What are they supposed to do?
Well, they could
They've taken
proceed
it.
by way of indictment. They didn't have to. The Commonwealth didn't have to muddy up the waters by starting the grand jury proceeding at the same time, too. That they could have just dismissed the district court case and proceeded with the grand jury. They could have indicted him on hearsay, Your Honor. They didn't need the attorney to testify. I mean, as they do routinely for indictment.
They could have indicted him on hearsay, but they couldn't try him on hearsay.
No, certainly
No.
not.
So where do they go? They get an indictment that's no good, that's subject to a motion to dismiss the next day.
But now that
But your point is that they have remedies here.
they have remedies, and any delay in this case is attributed to the Commonwealth. All the Rule 36 cases, Your Honor, deal with issues that the defendant has done, whether the defendant has acquiesced in a continuance request, or whether the defendant has filed motions. Or I would suggest, Your Honor, Your Honors, from the record, the only delay that I ever requested was from shortly after the arraignment until December 3rd, which was.
But you're
to
really
prepare for
challenging the
dangerousness.
stay. I mean, if the Commonwealth gets a stay, that's different. You're really challenging the stay and saying the stay shouldn't have entered.
Right.
You should just go ahead.
Well, he was just released from Bridgewater about a month ago, so I was waiting to, I didn't feel that there was good use of time and resources to try to argue something when he was committed to, under a civil commitment at the same time. But now that circumstance has changed.
And I know Justice Cowan answered you, but he's still in Bridgewater?
No, he's at Worcester State Hospital.
He's in Worcester State
Yes.
Hospital, okay.
Yes. So he's eligible to be released, and but for the order staying the trial court
Well,
ability.
why did he go back to Worcester rather than to a house of correction if you say he's eligible to be released?
Well, he still has some sort of a disorder. I'm just saying that commitment is different than the commitment of Bridgewater. There's no time period. He can be released if the hospital personnel deem him suitable to be released. But with the stay order in effect, he would be transported back to the house of correction rather than be released on his recognizance or some bail that the trial court sought appropriate. And so my main point, Your Honor, the only delays that I've contributed to was that brief delay of a couple of days in preparation for dangerousness hearing, and perhaps agreeing to continue the case for approximately 1 week at last February when the civil commitment had just began, and we were trying to determine whether or not he would be committed on that statute. Every other delay, every other procedural hoop that had been jumped through in this case was caused by the Commonwealth, not by the defendant.
Thank you, Mr. Vukmilovitz.
Thank you very much.